Hello, I'm Gary Bakke, and today I'd like to discuss with you some of the basic rules about how the divorce process works in Wisconsin. A divorce is started by drafting two documents. The first one is a summons. A summons is pretty much a standard form, and the function is to alert the other side of the case that a legal action has been commenced. The second document is called a petition. A petition contains all of the appropriate factual information, dates of birth, addresses, children, etc., and it ends with a request to the court to do something, such as grant the divorce, divide the property, provide alimony, child support, etc. The petition also must set forth the grounds for divorce. Why do you think you're entitled to a divorce? Grounds for divorce in Wisconsin are pretty straightforward and simple. The question is whether the marriage is irretrievably broken. If both of you agree that the marriage is irretrievably broken, the divorce will be granted. But that fact must be stated in the petition. After the divorce is started by drafting, filing, and then serving those two documents, the summons and petition, there's a required waiting period of at least 120 days before you're eligible for a trial. Now, as a general rule, trial doesn't occur that quickly. It takes quite a bit longer than that, but it's a mandatory waiting period that you should be aware of. During the period of time after the divorce is started and before you're eligible for a trial, sometimes it's necessary to have the court impose some rules, such as who uses the house, who pays for the car, who has custody of the children, what's child support, etc. That is handled usually in a temporary hearing scheduled before the family court commissioner. So normally we will have a temporary hearing shortly after the divorce is started and before it's final. Another thing to keep in mind, and that is that Wisconsin law provides for a mandatory disclosure of income and assets. There are potential penalties and economic consequences if anyone tries to hide important economic information from the court or from their spouse. There's a mandatory disclosure provided by statutes, and there are forms that are used to disclose appropriately all the assets. Each case is different, but the following are topics the court has to consider in rendering a judgment. Now, frequently the parties will agree to the resolution of these particular issues, but if they don't, the court is going to have to decide, and you're going to have to present evidence with respect to each of these issues before the court can render a judgment. The first issue that the court must decide is legal custody of minor children. Legal custody means the right to make decisions for a minor. Secondly, the court must decide about placement of children. Where are they going to live? The court will refer to primary placement or alternate placement. Alternate placement is sometimes otherwise referred to as visiting rights, but the court will refer to it as primary placement and alternate placement. Obviously, we can have situations where the placement is 50-50 of children, so we don't have either one being more primary than the other. The next issue for the court to consider is child support. Child support is governed by statute, which incorporates an administrative code which sets forth percentage standards for child support, and you and your attorney will have to be familiar with them, and the court is going to start with those standards. The next issue to be resolved is maintenance. Spousal maintenance is Wisconsin's word for alimony. The federal tax code talks about alimony, other states talks about alimony. That's identical to what Wisconsin calls maintenance. The objective of maintenance is to support a spouse that needs help supporting himself or herself, and to provide for fairness in the economic circumstances of your particular situation. The court will determine your income and that of your spouse and will set maintenance based upon those figures. However, under some circumstances where either one of you are not working up to your earning capacity, the court will consider what is your earning capacity if it's more than what you are actually earning at the present time. The starting point for determining maintenance is a 50-50 division of all income of both spouses. However, the courts are clear that that's the starting point. It is not the ending point, and the court must analyze about 10 specific factors to adjust maintenance that's appropriate in your particular circumstance. The next issue to be decided by the court is property division. One of the most important things to consider here is that all, and I mean all, property is subject to division by the court. That includes property that you or your spouse may have owned before you were married, and it includes retirement funds. The only exception to property that is to be divided by the court is property that has been received by gift or inheritance. And even in those situations where you may have received property by gift or inheritance, there are several complex rules for the court to apply to determine whether the property has retained its character as gifted or inherited. The law presumes that all property is to be divided 50-50. Again, there are statutory factors that the court will consider to modify that 50-50 presumption in most cases. However, in the property division situation, 50-50 is pretty standard in most circumstances, whereas back when we were talking about maintenance, 50-50 is more unusual. When we get done with the trial, it's going to be necessary to draft the final documents, and they can be somewhat complex. The final document is called a findings of fact, conclusions of law, and judgment. You will be required to draft those, or your attorney will be required to draft those, and that will encapsulate the entire judgment of the court for your future records.